Hello and welcome to Analysis. I am Oyi Adekunle. Now, there may be another governorship election in Bayelsa State soon, following a ruling of the Bayelsa State Gubernatorial Petition Tribunal, which nullified the election that brought Governor Diri into office. The election was nullified based on a petition by the Advanced Nigeria Democratic Party, ANDP, which argued that it was unlawfully excluded from participating in the election. In a split decision, the tribunal ruled that the Independent National Electoral Commission, INEC, erred when it disqualified the candidate of the ANDP, and the tribunal ordered INEC to conduct a fresh election within 90 days. Of course, Governor Diri has said he's appealing the judgment, but now let's get a legal perspective on this issue. I'm now being joined on the program by Barrister Evans Ufeli, of course, a legal practitioner. Thank you very much for joining us on the program, Mr. Evans.
Yeah, good afternoon.
Yeah, what was your reaction when you heard of the tribunal ruling?
Well, the tribunal ruling came as a result of INEC decision that excluded the candidate of the ANDP from the governorship election in Bayelsa State. INEC contention then was that the deputy gubernatorial candidate presented by the said party was not of age, was underage. And as a result of that, they were excluded. Even though the party made an attempt to substitute the candidate, but INEC wrote back to them, telling them that the time and the window within which substitution is supposed to be made has closed. And much so that according to Section 35 and Section 36 of the Electoral Act, a party must be validly nominated in the first place before it can be substituted. That the said deputy gubernatorial candidate of the ANDP was not validly nominated and so cannot be substituted. Those were the grounds upon which INEC held and restricted and excluded them from contesting that election. And they went to the tribunal. When they went to the tribunal, they brought the issue before the court that the Governor Diri was not properly elected because of the said exclusion. But then INEC had relied on Section 177 of the 1999 Constitution, which expressly states that to contest the governorship election of a state, you must be 35 years old. And then the deputy gubernatorial candidate for which the party presented on the affidavit that he deposed to INEC, he was 34. So that was the basis upon which that was done. And then when the Court of First Instance gave their judgment, they looked at it from the ground of the fact that they ought not to have been excluded, and then made the pronouncement that the governor was not properly elected. And so there is going to be a by-election which should be conducted 90 days from yesterday. But if you now go further to look at Section 142 of the Electoral Act, it laid down the procedure that when such judgment is given and is not appealed against within 21 days, then INEC will go ahead. But in this case, Governor Diri of the PDP have already said that he has implicit confidence in the judiciary, and as so, he is going to appeal the judgment. So as we speak, it's a judgment that is going to be appealed upon and all that. We look forward to the coming days to see how this will be tested in the Court of Appeal.
Of course, we're going to get to all of that. But let me ask you, now we saw in Zamfara State how INEC disqualified APC from contesting in the governorship election. And that was permitted at the time. Now, fast forward to this case, the tribunal is saying that INEC did not have the power to disqualify a candidate from contesting a governorship election.
Well, the case of Zamfara and Rivers State, it was not INEC that disqualified APC in the two states. It was not INEC. What happened was that the procedure for pre-election matters, that is primaries, the procedures for conducting primaries within the party and producing the flag bearer of the party was not followed. Remember that in Rivers State, instead of the APC to come together to have one uniform front to contest the primaries election and nominate a candidate, they created faction. The same thing happened in Zamfara State. They created faction and they were contesting, and the primaries are different fashion, and then accumulating candidates. And when they get to a point, they'll go to court to resolve it before they have a final candidate nominated. You understand? Mm-hmm. So the processes of primaries were flawed in Zamfara and River State. So what the court did was to say that because they have not put their house in order, because politicians within parties have not been able to follow through the process of primaries to arrive at a valid nomination for the contestation of election, it now disqualified the party outrightly. You understand? Mm. That is different from this. Okay, this is a case of exclusion. According to the ANDP, they were excluded. Then INEC said that the reason we excluded you is because your deputy candidate for the gubernatorial election was not qualified. You understand? So what the parties now saying that it does not lie in the mouth of INEC to determine who is qualified or who is not qualified. That even if the law has stated it is the court that will make such pronouncement as regards who should contest and who should not contest election.
Let's talk about the issue of substitution of candidates and disqualification now. Just about very recently, we saw the issue of the registration of political parties, appeal courts reversing INEC's decision. Because in this case, what INEC has said is that it disqualified the candidate of the ANDP for allegedly being underage at the time. And the party also said that they substituted the candidates. But INEC said it wasn't within the time frame. So was the electoral umpire wrong to have said that, look, you cannot participate in this election because you have substituted, the time when you substituted your candidates was wrong or was late?
No, yeah, you see, the Electoral Act is clear from that section 35 and 36. As regards substitution of candidates and nomination of candidates, okay? There's a window, there's a time within which such can be done, okay? If a party in its wisdom feel that the party they nominated is not qualified, or the party has one or two issues for which the party have resolved to substitute him, the party must do that within a specific time, okay? Now, the ANDP did not followed that. It was when INEC told them that their deputy nominee for the gubernatorial election is not qualified or was not qualified. That was when they now rushed to go and substitute. And as at the time they went to substitute, they do no longer have the time range, they no longer fall under the time within which to do that. So that is what actually happened. And the substitution is supposed to come under the radar of law. Otherwise, if you allow it open, there will be serious and gross abuse of substitution of candidates, and there will be a violation of the processes of law. That is why, in the wisdom of the legislature, they pegged it within a time. So any party that is unable to substitute or nominate within a particular time, you will not be able to contest such election. Like INEC said that you must submit the names of your nominees 90 days before the election. Okay, you must do that. And then if you want to substitute, you must come within so bracket, so time. You understand? So if you have not followed all that, it means that the patent provisions of law, you have violated them. You understand? So that is what it means. So it behoves on political parties to make sure that they screen their candidate proper. They get their legal department in the political party to look at the laws critically. You can imagine a political party, nominating someone who is not of age when it's clear under Section 177 of the Constitution that you must be 35 years old before you can vie for the office. And because it's a joint ticket, what affects one affects the other. And that is what the structure is.
in essence, what you're saying is, what was INEC right to have disqualified the candidates of the ANDP in this case? Based on what you have just said.
No, it's not as if INEC was right. It's not as if INEC was right. The matter was supposed to have been instituted as a pre-action matter, okay, to allow the court to determine whether or not, okay, the candidate is qualified to contest. You see, it is one thing for the law to say that this is what it is, but it does not lie in the mouth of an institution to be enforcing the interpretation of law. Okay, the court will have to interpret that section. Okay, so that is why if you look at section 285 of the 1999 Constitution, it sets the jurisdiction for pre-action matters before the Federal High Court and not the tribunal. So in this case, the ANDP camp did not, go through the pre-election matter procedure at the Federal High Court. Instead, they brought a petition at the tribunal, asking the tribunal to nullify the election based on their exclusion. You understand? Now, it's INEC's contention that the exclusion was done because of, the age issue. So, but that age issue should have been determined by a competent court and not INEC. So that is where you have the lopsidedness. It is not as if INEC is wrong or right, or whether the political party is wrong or right. It is that a court pronouncement was supposed to interpret that section to set the record straight upon which whether or not he should have been allowed to contest the election in that regard.
All right. So, Mr. Ufeli, please, we'll just have you hold your thoughts here. We'll go on a short break, and when we return, we'll continue this conversation. Please don't go away.
Hello? Yeah, I found your wallet in front of a supermarket. Meet me at Apple Junction. Yes, I'll be waiting for you.
Now we find out. Two of us.
Thank you very much, officer. It's surprising that men like you still exist in the police force.
Yes,
Oh, yes.
This is just a token of my appreciation.
Oh, no. You don't need to do this. We're only doing our job.
Thank you very much. God bless you.
You're welcome.
Now I know police is really my friend.
Yes.
Friend. Hey. Which came up with this one? I don't understand.
You know your problem. You are greedy. I'm a policeman who is doing his job. All forms of corruption in the force. Not in my country.
Corruption not in my country.
On Digi 360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
Constitution is constituent. Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgments so that you can make the right decision and take action. People are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country. I wish we had people like Tony at the National Assembly. God forbid that I go to join that band.
Digi 360, providing clarity to issues.
Welcome back. Now we're still talking about the tribunal ruling which nullified the Bayelsa State governorship election, and I still have standing by Evan Ufeli, who is a legal practitioner. Mr. Ufeli, let's continue this conversation now, and let's take it from the angle of, let's say, the implication now. Just last Saturday, a three-man panel of the tribunal had dismissed petitions challenging Diri's election victory. And now in a matter of maybe months, there may be a fresh election in that state. Where do you see all of this going? What do you consider the implication of all of this?
Well, the implication of the process is that most political parties in Nigeria don't do their homework very well. I mean, a political party should have a competent structure to evaluate and then make sure that their candidates are brought clean before the law, so that there will be no issues of disqualification within the scope. And then INEC also must try as much as possible to come within time and then initiate action in a court of law where they find that a candidate is making trouble as regards the processes of election and electioneering, and have a court make a pronouncement on issues like this before they go straight ahead and exclude. You see, when they do it, when they exclude candidates arbitrarily, it has a way of coming back to them, and it has a way of heating up the political climate in such a way that at the end of the day, the people will no longer know exactly who is making the choice of leadership for them. If you look at yesterday, you will find out that the APC supporters in Bayelsa went on the jubilation, believing that because the court have made such pronouncements, there will be a window, a room for Lion to contest election when and all that. You see that when already the Supreme Court have already rested the issue of APC as regards the election in that state, there's a pronouncement of the Supreme Court making a disqualification to the effect that the deputy who contested alongside Lion had 6 names within the age of 0 to 56 or thereabouts. And at every point, these names were changed and changed and changed to a point where even the affidavit they used to change the name, mistakes were also made in the affidavit. And it became so convoluted that the Supreme Court had to disqualify the deputy a day to inauguration of the election. So when you have this kind of thing, the political party, the APC, ought to have looked into the record of the deputy. You see, that's the implication I'm talking about. To check, to have a robust candidate that will be presented without blemish. Okay? The same thing happened in this particular party we're talking about. If the party had come clearly to evaluate and screen the candidate before they present the candidate with the deputy to INEC, they would have detected the age gap or the age bracket, and they would have been able to substitute even before they present or they make nominations. Okay, so the implication is that the political parties are not helping the electorate. INEC will want to follow the rules of law. INEC is the umpire. INEC have no candidate of its own. INEC is really looking at the Electoral Act, looking at the political parties, and looking at the law. So if you find discrepancies within the structure of the political party and their candidate for which they nominate, and you find a different step and narrative in the Electoral Act, the extant law that brought INEC, and you find a different thing in the Constitution, INEC will want to hold on to the law to make sure that the law keeps the sanity of the system. So that's the implication. If political parties work hard to make sure they present the best of their candidate without blemish, then the electorate will have faith in the system to vote for their choice, and then we will reduce the issue of going to tribunal and letting the court to decide who will lead the people, even when sometimes the court will make a pronouncement that is against the yearnings and wishes of the overwhelming majority of the electorate.
I totally agree with you. And that leads me also to you've talked about political parties, but let's look also at the judiciary. Now, this was an election that was held in November 2019, and this is August 2020, about 9 months after an election. Should we still be having court cases like this? And In this case now, will this even be treated as a pre-election matter or what? Just help us make sense.
It's supposed to be a pre-election matter, but it happened in such a way that the fact of the case allowed it to also come as a post-election matter. It's pre-election matter to the extent that the party ought to have taken INEC to court when they refused them nomination. Okay, they're supposed to have gone to the Federal High Court, take INEC to court, and then resolve it at that point. And court will make pronouncement whether or not they can be included. But since they didn't do that, they waited after the election. They still have a case after the election because they are now saying that the person elected is not properly elected because they were excluded. Do you understand? So, and it's part of the law, it's part of the Electoral Act on post-election matters that if a party is wrongfully excluded, the party have a right in law to bring an action before the court. So the matter happened, the fact of the case is such that it has one leg on pre-election angle and it has another leg on post-election angle to it. So they were able to make choice as to, since they did not meet up with INEC to resolve their position, they had to go post-election to have the total election nullified on the basis of their exclusion.
And lastly, before I let you go, you think that the Governor Doyediri stands a good chance when he goes to the appeal court? You think this is something he can win?
Well, it is forbidden to preempt the outcome of a court matter because once he goes on appeal, the matter becomes sub judice. And you cannot sit as a lawyer to begin to preempt what the outcome will be. But what we can say is that looking at the facts of the case, I mean, it was a result of 2-1, at the tribunal. Yes. 2-1. The chairman of the tribunal was the only dissenting voice. And then the other two went the way of the ANDP. So what we'll look at right now is that on appeal, what are the grounds of appeal? The grounds of appeal that Diri will bring out, will put in his appeal process, will determine actually the face of the matter. If you want to say that the tribunal erred in law, at what point and on what ground did they err in law? And it depends on how it is argued, looking at the constitution, looking at the age range of the deputy candidate of the ANDP, and then every other issues ancillary to laws. And it is on the basis of this that the law will make a pronouncement. But I believe that the party know exactly what to do, how to come up with its own grounds of appeal to determine the position of the law. And after the Court of Appeal, the Supreme Court is still there as a final arbiter on the matter.
All right. Barrister Evans Ofeli, thank you very much for joining us on the program.
You're welcome.
Yeah. That's the much we can take on this episode. Thank you so much for watching. I'll see you again next time. Bye-bye.